Hi, my name is Yogya Bhatia and I'm a legal intern at LEXIS and Company. Today I'll be talking about injunction. What is injunction? Injunction litigation is a crazy ride consisting of low points, high points, twists, turns and challenges. An injunction by its very name means a preventive relief. The grant of an injunction is an equitable remedy that prevents a defendant party from doing certain demonstrations or certain acts so that they are not bothersome or do not cause any nuisance to the plaintiff. When a court comes with a judgment in such a suit, the parties must abide by and adhere to the ruling, in the absence of which there can be severe monetary penalties or even imprisonment in a few cases. Explanation of important terms. Balance of convenience. The question of balance of convenience arises where there is uncertainty as to satisfactorily of the both respective remedies in damages available to either party or both. The parties must strike a proper balance and the balance cannot be a one-sided affair. Explanation prima facie. The word prima facie means either on first sight or on the first presence or on the face of it. Prima facie cases means that the recorded evidence should fairly enable the complainant's search for interference. Irreparable injury. Irreparable harm means any injury that cannot be fixed by damages adequately. The remedy in the form of damages would be sufficient if any is payable to the plaintiff in the case of victory in the litigation. It will not put him in the place where he was before the injunction was denied. Kinds of injunction. The Specific Relief Act 1963 discusses the various types of injunctions. To prevent possibly future injury to the plaintiff would have to bear if the relief is refused. There are certain kinds of injunctions provided as mentioned below. Temporary injunction, perpetual injunction and mandatory injunction. What is temporary injunction? Under the Specific Relief Act 1963, Section 37 deals with a temporary injunction. Temporary injunction continue for a specific period of time or until further order of the court. They may be allowed at any stage in a suit and are managed by the Code of Criminal Procedure. The essential purpose for granting this injunction is to secure the interests of an individual of the property of the suit until the final judgment is passed. The factors looked into while providing such an injunction are: if a party has a case of prima facie, if the balance of the convenience is in favor of the complainant, whether the plaintiff would suffer irreparable damages before the judgment is passed. The time period of such an injunction is dependent on the discretion of the court. This kind of injunction was also provided as under the case of Union India versus Bhuvneshwar Prasad. Some examples of cases stated in the CRPC where temporary injunction can be granted are where any property in dispute in a suit which is probable of getting wasted, destroyed, or is stranged by any party to the suit or illegally sold in execution of a decree, where the defendant threatens to remove or dispose of his property in order to defraud his creditors, where the defendant threatens to deprive the plaintiff of his property or threatens to cause injury to the plaintiff in connection with the property in dispute in the suit. In any case, to prevent the defendant from committing a breach of contract or any other injury, where pursuant to Section 38 and 34 of the Indian Relief Act, no perpetual injunction or mandatory injunction could be granted. Where to stay the operation of an order to transfer, suspension, reduction of rank, obligatory retirement, etc. In all cases except where the object of granting the injunction appears to be defeated by the delay even before the injunction is granted, the court shall issue a direct notice of request for the same to be given to the other party. Provided that there is proposed to grant an injunction without notice to the other party, the court records the reason for its view that the purpose granting injunction could be defeated by delay and requires the applicant to deliver to or send to the other party by registered post. Orders for injunction may be discharged, varied or set aside. The CRPC or the CPC also states that at the request of any party who is dissatisfied with the order or any order for injunction may be discharged or varied or set aside by the court, subject to the knowledge that if a party made a false or misleading statement in a request for a temporary injunction or in any affidavit support for such a request. Power to order interim sale. Upon application by any party to a lawsuit, the court may order the sale by any person named in that order and on such terms as it considers fit of any immovable property that is the subject of such a lawsuit or that is attached before a judgment in such a lawsuit. What is perpetual injunction? When perpetual injunction is granted by the judgment, it ultimately disposes of the injunction suit. It is ordered at the time when final judgment is given. It is a final relief injunction and is not given on an interim basis. The granting of a perpetual injunction is defined under Section 37, subsection 2 of the Specific Relief Act, 1963. The section says that only by the decree issued after an inquiry and on hearing the merits of the case can a perpetual injunction be granted. The defendant is thus perpetually enjoined to exercise his right as to forever pervade his conduct. What is mandatory injunction? Section 39 of the Specific Relief Act 1963 deals with the mandatory injunction. The section doesn't clearly define mandatory injunction but deals with the grant of mandatory injunction. The section says that in order to prevent the breach of an obligation, the court can compel the performance of certain actions at its discretion which it is capable of enforcing and can issue injunctions for the infringement complained of. The principle of mandatory injunction is used to grant final relief and not the interim relief, like in exceptional or exemplary cases like saving life, etc. Thank you.